Just recently, we were going around and around with a client who couldn't get their brain around the concept of the fact that their name was the only one that appeared on the deed.
Okay.
But they were married,
Uh-huh.
and they wanted to move the property into a trust. And we were explaining to them that to do so, you needed the spouse to join in the conveyance. And they said, well, it doesn't make any sense to me. Because I look at the deed, and my name's the only name on there as the owner of the property. Why does my spouse have to join?
Right.
And so we went around and around with them. And a lot of people just don't understand the fact that even though your name may be the only one that appears on the deed, if you are treating that property as your homestead, meaning your constitutional primary residence, Article 10, Section 4 says that that property can be transferred with spousal joinder. But the converse really demonstrates the rule. In other words, you may not transfer it.
Right.
Without spousal joinder. And you see lots of deeds that violate this, and people too often think, well, if the property appraiser, or the register of deeds rather, accepts it for recording, that's them blessing it as legally effective. That's not the case. That's just the register of deeds taking your recording fee and stamping it.
Right.
They're not giving you a grade on your work.
Right.
And so lots of deeds are done in error. And I think that's a big myth that we see addressed when people think that they're the only signature required
Right.
on that homestead property. Now, if that's not your homestead, it's fine for you to sign as the only grantor. So the status of the property is outcome determinative there on how many spouses need to sign in the conveyance.
Interesting.